Honourable member for Toronto-Danforth.
Thank you, Mr. Speaker. I'd like to actually begin where I was going to conclude with my speech after hearing the rather frankly arrogant question coming from the Parliamentary Secretary. We all know what this government does in committee time after time after time. Any amendment, however framed, however well framed, is voted down by the majority. There's almost a 0% passage rate of NDP or Liberal or, for that matter, any other independent members' amendments in committee in this Parliament. So to pretend that the fact of the writing of a few amendments by the opposition in this process would have made an iota of difference is the height of arrogance. I'd also like this House to know that in this context, most of the opposition witnesses were on the last 2 days, the majority were on the last day. The majority in this committee voted to make sure that the amendments from the opposition come in 3.5 hours after the session. Can you imagine, in the context of a complex bill like this, putting together well-crafted amendments when put up against an artificial deadline like that? This is the behaviour of this government in this committee. These committees do not function in any kind of straightforward or good faith legislative manner. Hear, hear. What I'd like to address in my remarks, Mr. Speaker, is how far C-42 diverges from and doesn't respect the recommendations from Justice O'Connor and the Arar Commission for a proper review mechanism for the RCMP. Most of the other interventions have talked about other areas of the bill and other issues, but I would like to talk a little bit about how the bill does take a small step in the direction of the Arar Commission recommendations, but ultimately stops far short. And this is consistent with how this government has truly resisted appropriate oversight mechanisms for any body that deals with policing or security matters. For example, in another bill that's before this House now, S7, the Combating Terrorism Act, they have stoutly resisted any form of serious oversight or monitoring. In my speech on that bill, I'll go into some detail on that. In each case, the NDP has proposed over a dozen carefully considered amendments that would help make good on the Arar Commission's exhaustive second report on a review mechanism. Yet every one was voted down or ruled out of order. This is consistent with the general approach of this government to the Arar Commission. I had the fortune to be in the committee, SECU, the Public Safety and Security Committee, when Minister Taves appeared to defend a report called Building Resilience Against Terrorism, and I asked him, what's the government's intention with respect to the recommendations on a review mechanism coming out of the Arar Commission report? It was absolutely clear from his response that the government had no interest in that report or using it as any kind of a reference point, baseline, or roadmap. And this bill, C-42, has made that completely clear. I'll proceed as follows. I will provide a short overview of what the Arar Commission did recommend by way of review mechanisms, and then I'll look at how C-42, in at least 4 points, does not take those recommendations at all seriously. The report I'm referring to from the Arar Commission is called A New Review Mechanism for the RCMP's National Security Activities. And before proposing the exact mechanisms, Justice O'Connor, who is and is of the Ontario Court of Appeal, outlined reasons for the inadequacy of existing accountability and review mechanisms for the RCMP's national security activity. And in general, he pointed out that there's been an evolution and a deepening of RCMP national security role, despite the fact that the CSIS itself was peeled off from the RCMP at some point. Obviously, in the post-2001 climate, we know that to be true and why that's true. Now, he emphasized 3 elements. First of all, there's been enhanced and deepened information sharing with other countries and amongst federal, provincial, and municipal agencies, and increased integration in national security policing. And we know, of course, that information sharing was at the heart of what happened to Mr. Arar. Secondly, he talked about comparative and other Canadian experience with both policing and security intelligence review that led him to conclude that there was, quote, an inability of complaint-based approaches to provide a firm foundation for ensuring that the often secret national security activities respect the law and rights and freedoms, end of quotation. And thirdly, he said that the existing Commission for Public Complaints of the RCMP has encountered, quote, difficulties in obtaining access to information from the RCMP, unquote. We'll see that that's the understatement of the century, Mr. Speaker, when we look at some of the testimony. And yes, Parliamentary Secretary, I did read the blues, and I did consider the testimony of various witnesses, including Mr. Kennedy, the former head of the CPC, whose testimony, frankly, is irrefutable, and the government did everything it could in committee to try to underplay and deflect the impact of that testimony. In terms of what Mr. O'Connor, Justice O'Connor, said about the new review mechanism, he emphasized a number of features the review mechanism that he was going to recommend would have. The first of all is that it must be authorized to conduct self-initiated reviews in the same way and to the same extent as CIRC, the Security Intelligence Review Committee that oversees CSIS. He talked about the need for these reviews at a time when, not just a time when the activities are deepening, but in a context in which national security activities by definition are conducted in secret and receive little by way of scrutiny or other independent scrutiny, judicial scrutiny or other independent scrutiny. And he emphasized how self-initiated review had to be linked to the criterion of independence from the RCMP and the government in the right of access to information and to initiate those reviews. The second feature that he felt would be important is that the body had to have investigative powers similar to those that public bodies have under the Inquiries Act. And he emphasized a few things. Some of them are in the bill. The right to subpoena documents and compel testimony. But also, the review body has to have the right to decide what information is necessary and not have barriers put in front of it in making that decision or in accessing the information. And thirdly, he said, quote, the review mechanism must not be hampered by jurisdictional boundaries. It must be able to follow the trail wherever it leads to ensure full and effective investigation or review of the RCMP's national security activities, end of quote. With those principles in mind, he went on to recommend a new independent complaints and national security review agency for the RCMP that would replace the CPC and would also take on the role he recommended for overseeing the CBSA, the Canadian Border Services Agency. He went on to talk about the need for coordination across the various bodies, this new body he recommended, the existing CIRC, Security Intelligence Review Committee, and the Commissioner for the CSE, the Commissioner for the Canadian Security Establishment, who also has broader and wider powers than what is found recommended in Bill C-42. So what is it in Bill C-42 that falls far short of these recommendations? The first major problem, Mr. Speaker, is that C-42 does not give the new review body uninhibited access to information that the body deems necessary and relevant. The Conservatives in committee tried to avoid acknowledging that this bill gives the power to the RCMP Commissioner to prevent examination and review of a broad range of privileged information. And we know from lots of experience how various bodies, including the RCMP, have abused the claim of privilege. Mr. Kennedy, the former head of the CPC, noted in testimony before the committee the findings of former Supreme Court Judge John Major in the Air India inquiry, who experienced firsthand the abuse of privilege by the RCMP. Here's what Mr. Kennedy said, quote, with reference to privilege, Justice Major, whom I talked to, was scathing in terms of his comments that the RCMP overclaimed privilege, concealed information from him, and in some cases of a witness who wanted to testify, they claimed they needed the information for investigative purposes, which wasn't true. End of quotation. The second major problem is that the RCMP Commissioner can force the chair of the new recommended body in the C-42, the CRCC, to suspend an investigation by means of a simple request in a letter on the grounds that it would compromise an ongoing investigation. Mr. Kennedy commented how this completely guts the credibility of this body in the eyes of the public. It completely undermines any sense of independence of the body. Third major problem, Mr. Speaker, is that this bill is largely devoid of time frames within which the RCMP must respond to requests and findings of this new review body. As Mr. Kennedy said, Mr. Speaker, and here I will end, quote, inordinate and unjustifiable delay was the hallmark of the RCMP during the 4+ years that I was chair of the Commission for Public Complaints. End of quotation. I'll end there. There's one fourth major problem, Mr. Speaker, but perhaps a question will elicit that. Thank you.
The honourable member may have an opportunity to address that in the course of questions and comments, which we're going to now. Questions and comments. Questions et commentaires. L'honourable député de Repentigny.
The honourable member for.
Thank you, Mr. Speaker, and I'd just like to make a comment on the honourable member's speech. I find it very interesting when the other side of the House disagrees with this side of the House. This side of the House is automatically wrong. There is a possibility that that side of the House is wrong. And because this side of the House does not accept an amendment as proposed by that side of the House, then again we are wrong. But, Mr. Speaker, the truth of the matter is that many of the amendments don't meet the constraints of the bill. They're outside of the bill. They don't add anything to the bill. In fact, they may well detract. So prior to the honourable member's speech, his view of what happens on this side of the House, I respectfully submit to you, is very clouded and very one-sided and without precedent in terms of any direct evidence that says what he is saying makes any more sense. Thank you, Mr. Speaker.
Honourable member for Toronto-Danforth.
I completely accept your observation that just because we take different views, it doesn't mean that one side is automatically right or wrong. I was simply responding to the rather strongly worded criticisms coming from the Parliamentary Secretary. I also pointed out the context in which amendments had to be drafted in this particular context. 3.5 hours after the end of the majority of opposition witnesses were there. I also noted that it is the practice of this government, working through the government members on committees, to accept virtually no amendments across all committees. If you have evidence to refute that claim, I would absolutely love to see it. Thank you.
The honourable member for Repentigny. Thank you, Mr. Speaker. I'd like to thank my honourable colleague for his presentation, and I myself wore the uniform and I found his observations interesting. He made excellent observations. I'd just like to hear what else he has to say.
We're the party of cooperation. I thank the honourable member. I was simply going to add one further point, which is that there is indeed something I would compliment the government for. They did include the chair-initiated complaints procedure, investigation procedure. However, it comes with a couple of conditions, and one of which is that the Commission, this new review body, cannot proceed on its own motion to investigate, quote, if there is another review or inquiry that's been undertaken on substantially the same issue by a federal or provincial entity. Now, this may seem like a reasonable provision, but it opens the door for delay and challenges by the RCMP, including in court. The judgment about whether or not it's germane to the Commission to initiate its own investigations, frankly, should be with the Commission. And there shouldn't be a mechanism whereby the RCMP can push back, including by using and drawing on government lawyers. And there's a further provision that indicates that possibly the minister himself or herself could challenge. And so the granting of chair or commission-initiated review or investigation is partly undercut by these conditions. And that was my only other point. Thank you, Mr. Speaker.